Board for discussion. Mr. David Poteet represents this district, and he'll lead us in that discussion. David?
Well, this has been an interesting, to say the least, variance. I've done a lot of research, educated myself in every aspect I feel that needs to be done. I was a reporter. I prided myself on not making where we have to write retractions, and I've done the due diligence on this case to do my very best at all parties to look at what we're looking at here. I've had good discussions with Mr. Pond. I've met with his nice daughter there. I've met with the chickens and even with the dog that plays soccer in his yard. So I've also had 50 or more emails and phone conversations based on this variance, about half for it, about half against it. It was split right down the middle as best I could tell and look back on my records. During the process, and today we wanted to look at a couple things, and he cited section 134-271 of Cobb County Code, which includes special exceptions. I looked at it and had a couple questions. Two questions for Mr. Atkins, if I could, our county attorney, if you don't mind. I hate to put you on the spot here. One, does the special exception, I took it as a land exception, does it include livestock? Did I read that wrong? Second, are hardships what this board can consider by law?
Well, I think that the first thing is special exception or not, excuse me, the first thing you've got to operate under is your own code section, which is the BZA code section, which was cited partially but not completely in terms of your consideration of hardships. And it breaks it down and gives you several subcategories there. So no matter whether the special exception applies or not, you still have to go through that same process. In this case, the special exception does not apply for a number of reasons, but right off the bat, you're limited on lot size reductions in R20 to going below 20. You can't go more than 25% down. You know that. You do that all the time. Typically, when you see those, it's when someone comes in to ask for a rezoning, and those, of course, have to go to the Board of Commissioners later for approval. But this would be the same as that. This lot is an R20 lot, so you're talking about significantly more than a 25% reduction, which you are not allowed by law to do. So that alone is a reason why special exception is not applicable here. But in addition to that, and I'm sorry, I think I'm getting some feedback on my microphone, but in addition to that, there's really no specific provision in special exceptions for livestock. Again, that procedure was put in place primarily for situations where people need to get a lot size reduction to then go on and apply for a rezoning.
Okay. And hardships? The
hardships, as I said earlier, you have to apply that analysis to every request that you get. The hardship does not, as we've seen before recently in the last year, the hardship really doesn't relate to the personal characteristics of maybe who lives on the property, who works on the property. The hardship relates to the property, the shape of the property, the topography of the property, something unusual. As you saw today, there were several other cases where we had one lot, for example, that was a five-sided lot. That sort of thing is what the hardships apply to. You know, I'll leave it to you to decide whether or not there are any of those hardships here. That's not my place to tell you, but that's the sort of thing you're looking at. You're looking at the property itself. You're not looking at the personal situation of people that live on the property.
Thank you.
Does that answer your question?
I think so. Yes, I know so. You know, some of these are hard because we have families involved, and some of them we have families, kids. I have kids, and I know what that's like. So it's never fun doing some either way sometimes. I told you 40% a minute ago. I would never vote 40% impervious over. There's certain things we go to. And after listening to all the facts and the people involved in the situation, and I can assure you I did listen and I did read and I did study. I went online and studied about chickens. I know chickens now to a certain degree that I didn't know before. But for me it's come down, not whether I like chickens or dislike chickens or have no opinion on backyard chickens. It comes down to the role of this board, as I can see, by law. And I know this is not a variance issue in my heart, it's a code issue. I believe that with all my heart and sincerity. I was waiting for something today to maybe show me something different. It was a good presentation by Mr. Pond. However, I still, from what I've looked at and talking to legal, I'm still where I was at with that everything I've looked into tells me under these circumstances, we would virtually nullify the Cobb County Code, which is not our job. That's at the discretion of the commissioners. And I think if we okay this variance, we're overstepping our boundaries as a board. I believe that 100%.
Okay, any other comments from board members? Ms. Williams?
I think when the ordinance was adopted back in 1972, and it pertained to having chicken or poultry on less than 2 acres, it was written for a really good reason. And one of the reasons is you couldn't distinguish between if somebody had chickens in their backyard or if somebody wanted a pig in their backyard, and believe me, we've had requests for pigs in the backyard. You have no place to draw the line. So one of the reasons that we have never, correct me, John, if I'm wrong, we've never granted a variance for chickens on less than 2 acres. Am I correct in that? Okay. And that reason is to protect all the property owners. The property owners, as they stated, you can see, hear, and smell chickens. You can hear, if you had other livestock in the backyard, you can see it. So that is one of the reasons that would cause me, besides the size of the lot, to say that I would not recommend approval of it.
All right, comments? Any other comments from board members? Not hearing any. David, we're back for motion.
With all that said, I think it's no surprise I'd recommend denial of this application. However, instead of the 30 days, I would like to give the Ponds 30 days to figure out what his next step is or to come in compliance with code.
Is that a total of 30 days? Or?
Excuse me, 60.
Okay. So
60.
we have a motion for denial with a 60-day removal. Is that correct? Okay, that's his motion. Do I have a second to that motion? Second for discussion. Any discussion on that? 60 days is a long time, David, but Ms. Williams?
What was your thought process in the 60
Well,
days?
you've got, to me, you've got live animals. You've got 11 or, I don't know if Mr. Ponce has the 13, but 11. You've got the coop itself and stuff. You may be able to find a home for those chickens in 60 days. You may not. You may be rushed in 30 days. So my thought would be that that gives him time to get the chickens and the home removed and find another home for those chickens.
And I'm thinking of the neighbor who's wanting to sit and enjoy her privacy in her backyard.
How about we go 45 days? You want to split that? David, let's...
If that gets us an extension, that would.
Okay.
If that gets us an extension.
What- You want to make the amendment to 45
Yeah, I'll make
days?
amend it to 45 days.
Second is okay with that. Our second is okay with that. All right, have a motion to have a second. No other discussion. I'll call for the vote. All in favor signify by saying aye. Aye. Any opposed? Okay, Madam Secretary, we deny case number V65, and we give the applicant 45 days to remove the problems. Okay, John, what's our next case?
Yes, sir, Mr. Chairman. Variance case of V71,